Theoretical jurisprudence. Dear colleagues at bar, dear students, ladies and gentlemen, this is the topic for my today's discussion, theoretical jurisprudence. But before that dedication, I hereby dedicate this movie to one of my teacher of primary school, Master Saki साहब, जिन्होंने मेरी बुनियाद रखी थी एजुकेशन की. थैंक यू वेरी मच सर साकी, जहाँ भी हैं आप खुश रहें. एक्चुअली लेडीज़ एंड जेंटलमैन, बात शुरू करना चाहूँगा कि व्हाट इज़ jurisprudence. Jurisprudence means knowledge of law, philosophy of law. Jurisprudence has been derived from two Latin words, juris and prudentia. Juris means law and prudentia means knowledge of law. So jurisprudence means knowledge of law, philosophy of law, grammar of law, mother of all the laws, investigation into different concepts of law. Now, jurisprudence is further divided into two kinds. मैं कोशिश करूँगा ज़रा बहुत टेक्निकल टर्मिनोलॉजी यूज़ ना करूँ ताकि पब्लिक एट लार्ज भी जो लॉ की टर्मिनोलॉजी से वाकिफ़ नहीं है वो भी इस्तिफ़ादा हासिल कर सकें. There are two kinds of jurisprudence. One is theoretical jurisprudence and the other is practical jurisprudence. In theoretical jurisprudence, we discuss different principles of law. And in practical jurisprudence, we discuss the law. अब दो चीज़ें हो गई, principles of law and the law. Well, laws of one country may be different than the laws of another country. But so far as these basic fundamental principles of theoretical jurisprudence are concerned, those are the identical same all over the world. So, in theoretical jurisprudence, this kind of jurisprudence, we discuss different principles of law. कुछ principles of law होते हैं जी, established principles of law. और सारी दुनिया में फिर उनको सामने रख कर लॉ मेकिंग होती है. कवानीन जो बनाए जाते हैं उनको सामने रख के बनाए जाते हैं. लेजिस्लेशन जो होती है उनके लिए माइलस्टोन मैं कह सकता हूँ होते हैं. फॉर एग्जाम्पल, एक बेसिक फंडामेंटल पहला प्रिंसिपल ऑफ लॉ जिसे कहते हैं वो है नो वन शुड बी कंडेम्ड अनहर्ड. यानी किसी शख्स का मौक़िफ़ सुने बगैर, उसको सफाई का मौका दिए बगैर उसके मतलब कोई राय कायम नहीं करनी चाहिए. जिसे लैटिन एक्सप्रेशन में कहा जाता है नो वन शुड बी कंडेम्ड अनहर्ड को प्रिंसिपल ऑफ ऑडियो अल्टम पाल्टम, principle of audio altum partum, meaning thereby no one should be condemned unheard. Now this is the basic fundamental principle of law. Similarly, criminal practice में it is established principle that it is duty of the prosecution to prove the guilt and accused need not to prove himself innocent. So it is always duty on the shoulders of the prosecution to prove the guilt through evidence beyond any shadow of doubt. Similarly, so this is a principle of law कि इस्तिहासा ने साबित करना. Similarly, एक प्रिंसिपल है that वो भी क्रिमिनल केसेस में हम यूज़ करते हैं कि benefit of doubt is right of the accused person. So if some doubt arises, it is right of the accused person. So this is also another principle of law. Yeah, जिस तरह हम कहते हैं all are equal before law. So this is also a principle of law. Then criminology का ही एक और principle है that act alone is never an offense. Act alone is not an offense until and unless mens rea is there. Now what is mens rea? Mens rea means criminal guilt, intention to commit a crime. So mere act all over the world is never an offense. जब तक उसमें जो accused है ये प्रूव नहीं हो जाता कि ये जुर्म करने की इंटेंशन भी रखता था. नीयत मुजरमाना भी थी. Mens rea is a necessary ingredient of a crime. There are two ingredients of a crime. One is actus rea and the other is mens rea, and union of these two elements constitute a crime. This is another principle of law. Similarly, one principle of law which governs the entire law of evidence, and that is verbal evidence in all the cases must be the direct evidence, meaning thereby hearsay evidence, सुनी सुनाई शहादत कानून की नज़र में कोई शहादत नहीं होती. This is another principle of law. So, to cut it short, my dear fellows, theoretical jurisprudence is one of the kind of jurisprudence, and jurisprudence means knowledge of law. In theoretical jurisprudence, we discuss different principles of law, and in practical jurisprudence, we discuss the law. And some principles which I have discussed with you today is no one should be condemned unheard, principle of audio altum partem, benefit of doubt is right of the accused person, another principle, duty of the prosecution to prove the guilt beyond shadow of doubt, all are equal before law, and act alone is never an offense unless mens rea is there, and mens rea means criminal guilt, intention to commit a crime. Or yahi, it will not be out of place to mention that there are two kinds of mens rea. One is willful wrongs and others will wrongs with negligence. So negligence is also one of the kind of mens rea. Willful wrong and wrongs with negligence. So these are some fundamental basic principles of theoretical jurisprudence. And with this, I say goodbye, stay blessed, be happy. Thank you.